Hi, my name is Sira Boats, and I'm an occupational therapist and a dementia specialist, and I'm also a daughter of dementia. And here at Boats Memory Method, we want to provide you hope on the dementia journey. And today, I have a very special lady with me. Her name is Katie Flores, and she is the estate planning and elder law attorney at Dignity and Trust Law in Newbury here in Florida. And she has been married to her husband, Glenn, for 13 years. They have 4 children. And Katie is a triple gator, meaning she graduated from the University of Florida here in Gainesville, and she earned 3 degrees there. She earned her undergraduate degree, her law degree, and a Master of Taxes of Laws, a Master of Laws in Taxation. And it is also her birthday today, Katie. Happy birthday, and thank you for joining us on this special day. And please introduce yourself to our audience.
Thank you, Sarah. As Sarah said, I'm Katie Flores, and I am an attorney here in the North Central Florida area. So I practice just west of Gainesville in Newbury, and I serve clients of all ages, families, folks who are aging, and I make estate plans, and I help families prepare for all of those decisions that need to be made when they are getting closer.
That is wonderful, and it's so necessary, estate planning, as we see a larger population aging. But Katie, what prompted you to end up with your own practice in estate planning? Tell us a little bit about your passion.
Sure. So when I went to law school, I studied estate planning and I got my Master of Laws in Taxation to prepare myself for this. I knew that eventually I wanted to work with families and help them plan their estates, but I got a job offer from an internship firm that I had worked with, and it was in litigation. So I did several years of litigation work, and what I found was really surprising to me. There were families who thought they had done what was right, and they had created estate plans, but they didn't realize that they had to revisit those estate plans as life changed, or maybe they didn't have estate plans at all, and families just ended up in court fighting over what was left behind. And it was devastating to me as a brand new attorney to see that people could have avoided so much stress, so much expense, and so many familial relationships that broke apart because they ended up in a courtroom instead of having things decided ahead of time.
Right. And with AI, I'm sure you're seeing some breakdown too, with people using AI and then maybe not having all the I's dotted and the T's crossed like they should.
Yes. I have spoken with several people recently who are interested in AI and showed me some, examples, and I certainly kind of have played around with the various platforms to see what it's offering. And there probably will come a day when AI could do a lot of what you would handle through a transactional attorney like myself. But from what I'm seeing right now, it's not very reliable, and there's such a thing as AI hallucination.
Yeah, AI makes mistakes.
It does.
We don't know it, but the AI is programmed to offer you something that satisfies you, and it's not necessarily accurate.
Yes. And there have even been attorneys who have gotten in trouble with their state bar and judges whose clerks have sort of done research with AI, and AI will come up with a fake set of citations for the law, and it's not real. So it's not there yet.
Be careful to use your estate planners, your attorneys. Do not rely on AI yet.
Yeah, well, we're not there yet.
But tell me, you had a interesting situation or case study that kind of triggered this passion or created this, was a catalyst basically for you to move into the type of law that you're doing, especially in relation to elder law and people living with dementia.
Yes. So there was a case that happened when I was in litigation. This case came to us because the son of an elderly lady noticed that his sister was selling properties that belonged to his mom, and he wasn't as involved in his mom's life at this point, and so he lived further away. He meant well, but just was not involved enough to keep an eye on things. Unfortunately, this lady, she did have an estate plan, but it didn't work for her. So she was in her early 80s, and she had amassed several rental properties that were her income source. So she was managing really well for a while. And her estate plan, I guess for whatever reason, didn't come to mind. She didn't think of keeping it updated. It had been about 20 years between when the estate plan was created and when she really needed it to work. And as you can imagine, someone's life looks very different 20 years different in
a gap, 20-year gap.
A 20-year gap
happens.
is huge. Yes. So this lady had named people, not her children, but other people, to be in charge of making decisions for her if she couldn't make those decisions herself. But 2 of them had passed away, and another one had lost touch with her and lived out of state. And so by the time she needed this estate plan, she was very vulnerable. And I think to a certain extent probably realized that her daughter was very opportunistic, lived locally, and took the mom to an attorney's office to have a durable power of attorney drawn up and signed. A durable power of attorney is a very powerful document. They're very important, but they can lead someone down a very dangerous path if they don't pick the right person to make these decisions for them. You're handing the keys to the kingdom to someone and saying, you can do anything and everything in my place. And so, unfortunately for this lady, sometimes I call her Dottie. That's not her real name. And I protect confidentiality. But Dottie, she, for whatever reason, whether she felt like she was backed into a corner or whether her daughter, lied to her and told her that the document was different from what it actually was.
Yes.
She did sign this very powerful document. And then her daughter proceeded to start selling off the rental properties and keeping the money for herself. Now, Dottie's estate plan, her wish was to stay in place in her home. She had a beautiful, generously sized home, and she had enough space where a nurse or a live-in care worker could have actually come and stayed with her so that...
Do we want to stop with this knocking?
No, it shouldn't pick up.
It shouldn't pick it up?
Okay.
I'm sorry.
That's
I just
okay.
was thinking about the noise of last time. That's interesting.
Yeah. Sounds like some kind of machine or something.
So, okay. Sorry. Got so you can get to start with the home. She had a sizable home.
So Dottie had a sizable home, and it had enough space for a care worker to come and to live with her. It was all set where she had the financial means to be able to do that.
To age in place. What
to
she wanted
age in
to
place,
do.
exactly. Yeah. She didn't want to go to a nursing home. But when the daughter had durable power of attorney, she was able to start arranging things for the daughter's benefit instead of for Dottie's benefit. And so the daughter put Dottie in a nursing home. The daughter moved her own family into Dottie's home and took over. And by the time we got involved, so much of the money had changed hands. It was in the hands of the daughter. And because everything was done under a legally validly executed document, there was almost nothing we could do in litigation. So unfortunately, we weren't able to solve the problem. And as a young, fresh attorney, it really deeply bothered me. I saw this lady who had a plan and it wasn't honored because of a gap in what her estate plan said. And it was awful.
And then also it sounds like attorneys that was rushing through a situation that was not really in tune with the elder needs, the elder law, not really careful with how they drafted this document.
Yes.
And so that's another part of it is having an attorney or an elder law attorney involved that really are passionate about the outcomes that you're seeking for versus an attorney that's just going to push you through the mill. Like you placed it, you said very nicely, a paper, what's the term you used?
A document drafting factory.
That's it, the document drafting factory. That's not what you want. When you are looking for a good elder law attorney, you're looking for somebody that is going to connect with you on a deeper level, that's going to understand you and your family situation and be able to really lay out a path for you that makes sense for everybody involved.
Yes. And it's so important for an attorney not just to say, well, who do you want to name? And yes, we'll create these documents. This is what you need, and just sort of push their ideas on you, but for them to really be a listener, for them to look at your relationships in your life. Who do you trust? Why do you trust them? Are you sure there shouldn't be some kind of accountability built in?
Right.
Sometimes.
And then understanding strengths and weaknesses within the family structure.
Yes.
So that you can make those recommendations. So you're looking for an attorney that can listen. And as we age, this is so important. And we're going to get to that a little bit. But here I am, and I'm consider myself younger. And I'm in the middle of working with this on this with you. And it's so important that we not only to look at the estate planning, but like you touched on, durable power of attorney, healthcare surrogates, your living will. What does it want to? What do you want to have your life look like towards the end of life? So tell our audience, Katie, we're going to break this down, and we're going to break it down into several questions that I'm sure our audience will have, because I had those questions. Why is this such an important step to take?
That's a great question. So when someone calls my office and they have a problem, and the solution, part of that solution is a durable power of attorney, it's always the person who's named in the document. It's not the person who created the document. So by the time you're coming to the point where you need this document, you're probably not going to have your full mental faculties to be able to make really good decisions. A lot of times families that don't plan ahead, they're under this very stressful situation where there's a quick decline either in cognition or even physically, and someone can't, fully wrap their head around making their own plans. And so that's part of it, is that when we really need these documents, we're already in a bad place.
Right. So you have to start sooner.
Yes.
Yeah.
And the other part of it is that none of us know what's going to happen tomorrow. I don't know where my day will end. I mean, we all hope that tomorrow and the day after are good, healthy days. But in case they're not, every single person who's a legal adult needs to have decision makers set aside ahead of time.
Yes, absolutely. And so describe to us quickly what is a durable power of attorney. And then I would like for you to describe also to us what is a healthcare surrogate and what is a living will. I think sometimes those things run together for us, and we don't understand the differences and maybe why they need it. So let's start with a POA. In healthcare, we typically talk about, do you have a POA? And people will say, what's a POA? So can you just give us a definition on what that is?
Yes. So a durable power of attorney is a document that gives legal and financial decision-making power to someone else. So when you hear power of attorney, that just means someone has a permission slip and they can make decisions on your behalf. They can sign your name for you on the dotted line. When it's durable, that means it is effective. Even if you lose your capacity, this person still gets to continue making legal decisions for you. And most of the time, these are very broad. They're very powerful. And for that reason, they're important because they're essential if you want to avoid other court proceedings.
Especially if you're on the dementia journey.
Yes.
And you know that certain things are
certain
coming and you are going to decline. So it can be that you are a lily, meaning you're at the beginning stages. You understand that you have a diagnosis and that you may decline over time. So you are taking these important steps now. Or you may be a daisy where you can, in the moment, you can have a conversation with an attorney. You know your likes, your dislikes, you know your wishes, but you don't necessarily remember that you've made certain decisions. So in the case of a daisy, that's going to be a conversation with a spouse or a family member or a direct caregiver that's assisting them to the lawyer's office. In the case of a violet, at this point, we're too late. Because then this person cannot make choices for themselves anymore. They are disoriented. They don't remember a day and place. They may not remember faces. They may remember the names of family members, faces of family members, but they cannot remember beyond what happens right here and right now. And then at our rose level, which is severe cognitive decline, this person can barely respond to yes and no questions. They can barely hold an interaction for 5 minutes. They're completely dependent. Although they may be walking and talking, they're dependent on a caregiver to manage their day well. And then, of course, at our end stages, at our bouquet level, this person is hospice ready. At this point, we should already have had all of our POAs, our living will, our end of life wishes should be in place, and we are executing it. So for me, it's just so important that our audience understand that we start upstream, like you said, way before it's even necessary. Hopefully, even before any of us have any kind of diagnosis,
Yes.
we want to have this in place. But then even when there is a diagnosis, especially if it's early on in the journey, your loved one can be included in this decision-making process. It should be included
Yes.
as much as possible. So that is your durable power of attorney. And as in your example, you talked about it can be so powerful because if it's in the wrong hands or somebody that does not honor your wishes, then it may not turn out the way you wanted to turn out. Now talk about the healthcare surrogate for me, please. And what does that mean?
Yes. So the designation of healthcare surrogate is the document where you name who's going to make your healthcare decisions if you can't make them for yourself. Sometimes they're called advance directives, and that's kind of a broader term that includes living wills and that sort of end-of-life care decision-making, which we'll get to.
Right.
But yeah, a designation of healthcare surrogate is a document that picks a set of people or a person to make your healthcare decisions for at any point when you're not able to make them for yourself.
So you can have both. You can have a durable power of attorney, which is somebody that can sign for you, basically manage your money. And then you can also have healthcare surrogates that maybe you have somebody in the family that's very strong financially, and you want them to handle your investments and your properties, and you know that they'll make good financial decisions. But maybe you have a physician or a nurse that is a very strong healthcare partner that don't necessarily want to deal with the money piece, and then they can be your healthcare surrogate. Is that correct?
Yes, and sometimes it works out really well that way, especially if there's going to be a cognitive decline. It could be a lot of responsibility to have both the financial side and the healthcare side of things. And sometimes with a lot of families, I find they feel more comfortable sort of dividing those roles and having one person as the financial person and one person as the healthcare person. And it could be the same one. There's also a question of accountability. Sometimes it's nicer to have two separate people in those roles so that they can look over each other's shoulders and they're making sure that the other decision maker is doing
making
what's
sound
best.
decisions. I love that accountability piece. Absolutely love that. And also with when there's so much burnout for caregivers.
Yes.
And I think looking to the future of the amount of care that I may need if I'm the person with a diagnosis, or if you're a family making a decision on a long-term journey for this person, coming back to what we talked about, knowing the strengths of the different family members and what you're passionate about, and knowing that if you that you pick the load that you want to carry because that's something you do well.
Yes.
And allowing your siblings or the rest of the family to pick up a load that they do well, so that not one person carries the whole load and burn out in the end. I see that so much, where the responsibility falls to one person, and that one person is great at the beginning. They have all the skills, they have the mindset, but as this journey progresses, that, like you said, that burden becomes so much, and it's such a good idea to have that accountability partners in this journey so that you can bounce ideas from each other, make decisions together. Absolutely love that. So then we get to the living will. So can you please unpack that for us?
Yes. So a living will is the document where you put your wishes for your end-of-life care decisions ahead of time. So if you're in a terminal or an end-stage condition or a persistent vegetative state, you can say ahead of time, these are the types of things that I want you to do for me, versus sometimes a lot of a living will has to do with this sense of, I don't want to feel pain, please keep me comfortable, but let me go. I want to die a natural death. I don't want to be kept alive on machines.
Right. And it also has to do with resuscitation, right?
Yes.
Do I want to be resuscitated, or do I not want to be resuscitated? In the medical field, we talk about DNR, meaning do not resuscitate. And that's part of that living will situation, correct?
Somewhat, yes. So a DNR is a little more medical facility specific, as far as, usually it's your doctor's office or the hospital system that's going to have the DNR, and they're going to put it in as as
A
their
measure.
set of instructions. Yes,
Yeah.
yes, their measure.
But that DNR needs to be decided upon by either the healthcare surrogate or the durable power of attorney if that person doesn't have capacity.
Yes.
So just as a little dot
Yes.
on this journey, this is something that you need to consider, that when you take on these responsibilities, that you talk to your loved one. If you're the person living with a diagnosis, I need to have that the decision making strategies in place. I have to have had that conversation with my family members as to what does this whole journey look like for me. And a DNR can be a scary thing. As a healthcare professional, we run into that a lot with families that do not have a DNR in place. They don't have a durable power of attorney in place. A lot of times, then what do we do next? Because we cannot make that decision. So it's so important to talk about these things up front. I just wanted to touch on living well as well, as it relates to healthcare and dementia. Consider the journey, the dementia journey. Consider the fact that maybe you will end up incontinent. So, and do you want to be catheterized? Or are you happy with just wearing pull-ups? You may not be able to chew and swallow the way that you should once you get to the rose level and to the bouquet level. So do you want your nutrition to change? Do you want to be fed pureed food or thickened liquids, or have a G-tube, a feeding tube? Or do you not want any of that measures? We have somebody who told us, listen, I'm going to eat steak until the end of my life. And if I choke on my steak, then that's fine. That's how I want to go. So this is the kind of detailed decision making that you need to think about. And Katie, you touched on that. As I move as a Lily, I can live alone. I can have measures such as alarms and calendars and clocks and reminders in place that keep me on track to help me with some of my memory loss. As a Daisy, an extra layer to the alarms and the clocks and the calendar use, the extra layer can be a caregiver that supervises me with when we're driving, when we go to appointments, somebody that supervises my medication, somebody that checks in with me regularly during the day to make sure I'm on track. But by the time we get to the violet level, now we really need to have caregiving in place. So as Katie was talking about our case study, Dottie had in her will that she wanted to stay home with caregivers. And at the violet level, at that journey, dementia, at that part of this journey, we have to seriously consider what caregiving looks like. 24 caregiving and that burden. What does that burden look like? Is it that we're splitting that burden for family members? Are we having the spouse do it all? Are we enlisting a senior daycare? Are we maybe paying for night caregivers to come in? So as part of that living well and that long-term planning, for me as a dementia consultant, that's where we have to really start thinking and talking to the family. So what does this look like when we get to the moderate stages and the severe stages, when your person is needing more care? When we get to the rose stage, now this person needs bathing, they need dressing, they need assistance with eating. What will that look like for your family? And what type of decisions? And if I'm the one with the diagnosis, what do I want that to look like for me?
Yes.
So I think just with the dementia, on the dementia journey, these are some of the things that I would like for our audience to consider when you're meeting with your elder law attorney, to talk through the needs that you may have. And then that brings us to the cost of that needs. But we're going to get to the how do we cover the cost. Just quickly, we're talking about elder law attorney. we're talking about getting older and having all your paperwork in place. But what is the right age? What's the golden age for us to start doing this?
Yeah, so it really should be anyone who is of legal decision-making age. So if you're 18, or maybe you're the parent of an 18-year-old or a fresh college student, you need to make sure that if something, God forbid, should happen to them, you have something in place that says, yes, I can go and, make decisions for my son or daughter if they're in an accident, or, if they're suddenly incapacitated, even if it's something temporary.
Right.
And then really throughout your life, anytime you have a major life change, I tell my clients, if you're not sure, it doesn't hurt to kind of take another look at the documents, maybe ask a professional. I encourage my clients to just have a simple, quick conversation with me. Give us a call at the office, and we'll determine whether your document needs to change. But if the people in your life who, maybe you made your plan and you named some really good close friends, and then all of a sudden they get a job offer across the country and they're not going to be nearby anymore, maybe then you need to change the documents, and
right.
They should definitely
or maybe have
follow.
loved ones on that document and they pass away.
Yes, exactly.
Suddenly, and now they're not there anymore.
Yes.
So when you get married, when you have children, when you get divorced, maybe
Definitely.
when you buy a new home,
Yes.
maybe like my situation, I acquired a private business, and I have a home that I live in a rental home, and I have an adult daughter and a teenage daughter. So there's a lot of dynamics there.
Yes.
And I'm a caregiver as well. So how do we talk about all of those factors and have a document in place that, especially if something happens to me, how can my family make decisions to keep everything on, to be on track with what we're doing right now. So it's so important. So if the audience may be like deer in the headlight right now, listening to us talking about all these different documents and all the things that needs to happen, and maybe they have not taken that first step yet. So if they're sitting there thinking, oh my goodness, what do I do next? Can you kind of talk us through the process and what are things to do?
So I would encourage anyone who needs to have these documents in place, who's never created them before, talk with a professional, look for a local estate planning or elder law attorney. I would especially look for an elder law attorney if you are facing a dementia diagnosis or some kind of cognitive decline. That's so important. And
tell us, but what's the difference between a regular attorney and an elder law attorney? So why is it important that you choose an elder law attorney?
Yes. So someone who specializes in elder law is more familiar with things like applying for Medicaid. They're more familiar with rights and things that come along with, there's a very specific legal consideration when someone has cognitive decline, and you want someone who's familiar with assessing whether someone really has capacity to make the kinds of decisions they have to make. And
you guys are also trained and very sensitive to elder abuse.
Yes, and that too, looking for the signs of someone taking advantage of someone, which, you may not look like it on the outside, but there are certain cues and things that an experienced elder law attorney can look for. And an experienced elder law attorney is going to be familiar with maybe someone is always brought into the office with their son or their daughter or a care worker. You always want to separate out that client from whoever is bringing them and say, I'm sorry, you have to wait in the waiting room for a little bit, and really try and have a vulnerable, close conversation with the person who's making the documents to make sure that they really do feel safe with who's bringing them.
And on the flip side of that is that even if you're not in a situation where you are being abused, you are protecting that person from being abused in the future.
That too, yes.
Yeah.
Absolutely.
So it's so important. So tell us a little bit about, we touched on that, why an elder law attorney is so important. Tell us about estate planning and long-term care and Medicaid. So now we are in front of you. We know we need this. Maybe we have a parent that is already maybe moving from a daisy to a violet, meaning they are going from mild dementia to moderate dementia, and we are realizing the impact of this decline on their day-to-day function. We're realizing the impact it's having on us, and maybe mom and dad has indicated that they don't mind going into a memory care or a ALF, but now suddenly we realize, oh, how much is this going to cost? This is a lot of money. So for an average middle class American family, that can be a real hardship to place someone in long-term care. So can you talk to us a little bit about what that decision making and options look like?
Yes. So there is a very thorough set of consideration when you are thinking about long-term care or assisted living, and every state has different laws about this. So in the state of Florida, there are financial considerations and there are sort of physical and care needs considerations when you're trying to qualify for something called Medicaid. So Medicaid is a whole host of programs. It stems from the federal level, but then states have their own rules and parameters they're allowed to put around it. And with Medicaid, you are getting assistance in paying for either long-term care or assisted living, or sometimes even care within the home if someone is going to be aging in place at home. And there are different programs. So with the skilled nursing facility side of Medicaid,
which is considered long-term care, correct?
Yes, long-term care. Medicaid can come in and pay for that, $10,000 plus per month bill from the nursing facility. But you have to meet certain qualifications. So the medical side of things, you have to really need help with your daily living and care tasks and need to be sort of medically qualified. And then you have to have financial qualifications. So a person who qualifies for Medicaid can only have, in the state of Florida, $2,000 of countable assets. And when you think about only having $2,000 of countable assets to your name, that's very low. It's very hard to qualify. And so oftentimes you'll need to create a very special sort of financial plan for, maybe you have some resources, but for most of us, it's not going to be enough to indefinitely pay that $10,000 or more a month. And so
you can move assets around.
Yes, there are legal ways to things. So like in the state of Florida, your homestead is protected and doesn't count against you. So that's not a countable asset. Someone on Medicaid can own a vehicle. And so, maybe they're not driving anymore, but maybe they have limited mobility and they need a wheelchair accessible van or something like that. So sometimes those are things that you can invest the money that you can't have in your name into something that's going to make that person's life better.
Got you. And then they can still qualify for Medicaid.
Yes.
Correct.
And there are also income limits. So a person can only have certain amounts of income. But again, you can sort of set aside the excess income over the limit and put it into different kinds of financial instruments where you're promising the Medicaid agency that either this is going to pay for my portion of the nursing home bill, or it's going to pay for medical costs, or if there's anything left over at the end of my life, it will pay back the state Medicaid agency.
Got you.
So it's a way of
kind of with gap. Checks and balances to bring the government into your care, and making sure that it's done in a way that it's fair.
Yes.
To everybody.
Yes.
So don't just assume that I don't qualify for Medicaid because I have a homestead, because I have a car, because there are ways in which you can set up care for your loved one, in spite of the fact that you maybe have some income that push you over the limit.
Yes.
So that is very good to know. And of course, that is very individual to each person. And that's why you have to see your elder law attorney, because they're going to be able to determine with you what does that look like for your case, your personal situation.
Yes.
So if you have a loved one living with dementia and you don't know if they're legally competent or not, and that's very gray area, what should you do? And we touched a little bit on how important it is to understand where your person is at on their journey as far as a lily, daisy, violet, rose bouquet. There's very specific expectations that we can guide families with as far as how much does that person grasp of what's going around them, how good is their judgment, how much their memory and their orientation is impacting their decision making, and that changes from a lily to a daisy to a violet to a bouquet to a rose. But I would like your quick input on how you guys handle it in an elder law attorney's office.
Yes. So we have several conversations with the person with cognitive decline. So I would imagine if they're in that daisy stage, they may still have moments of enough clarity where they can make those decisions. Even I would say if someone is mostly a violet, but sometimes they have maybe moments of better clarity, sometimes there's still an opportunity to be able to catch them at a good moment when they're thinking clearly and they understand everything that they need to understand to make those decisions.
I love what you're saying there. I think, if you're a motivated caregiver, a very involved family member, you will know which times are the good times for your person. Are they a morning person? Are they better right after dinner or after lunch? I'm sorry. There's not a lot of us that's really good after dinner.
Yes.
I think we're all winding down for sleep time. But the times during the day that your loved one is most clear, and also maybe the person in your family that would be best suited to have the conversation, and also to bring them to the appointment.
Yes.
And I do want to agree with Katie on this. If a person is a lily, they can make that decisions on their own. They can definitely go to attorney office. They can have informed conversations. They can understand and track with the process. They may have to be reminded. They may need some hand-holding, but they can definitely take part in that process and be independent and make decisions. When we get to a daisy, this is somebody that may need a caregiver. Not that the caregiver is making the decisions. I think the daisy with assistance can make sound decisions for themselves as we guide them through the process. They cannot guide themselves through the process, but with guidance, they have enough understanding and the ability to process information. Again, they may not remember later what happened in that session, but during the session, they can process information and have enough capacity to say, yes, I want to go to a nursing home. No, I don't. Or I don't want to live with my son. I do want to live with my daughter, whatever the case may be. Versus when you get to a violet, even when you're under a circumstance where they're very clear and very with it, for a violet, the decision making is going to be very concrete in the moment, maybe between one or two things. Again, very guided conversation, and so very simplified, and up to about a middle violet. So if it's somebody that have some moments as a rose and some moments as a violet, maybe they won't have much capacity. But if you have somebody that functions most of the time as a violet, they can definitely make decisions between two concrete options. Do I want to live in this memory care facility or this memory care facility? Do I want my daughter to take care of me and bathe me, or do I want a caregiver to take care of me and bathe me? Sometimes we see at the violet level that people don't have as much insight as they should. So we do need the discernment of an elder law attorney and the discernment of a caregiver to know if the choice that the person on a violet level make is safe and is it reliable. So although they may have some good instincts on what they want, that may not always be what is necessary for the situation that they're in. So that may be hard to navigate. But again, if we keep it very concrete, very simple, step by step, then they can be involved to a certain extent, which just honor that person and their integrity as a person. But once we get to the rose and the violet dementia journey, I would say that ship has sailed. So what happens, Katie, if we get to severe dementia and the bouquet level, which is advanced dementia? Some of these persons may already be on hospice. What if they don't have a POA in place? They don't have a living will, but they have children that are very passionate. What does that look like?
Well, in situations where sometimes families, depending on what the situation is and how the finances are laid out, sometimes someone can continue to kind of make decisions even if they don't have power of attorney. So maybe it's a small town and, the bankers all know you there personally, and they, your name's been on the account, or, there are certain situations where sometimes families get along okay. And then at some point they're like, well, something's gotten worse and we can no longer make it work.
Right.
Sometimes there's an assessment of, is it worth doing a guardianship, which
and that requires
a court. So that requires hiring an attorney, and the court's job at that point is, because this person no longer can make the decision for themselves about who makes their decisions and who cares for them, the court is there to make sure that whoever is being named is vetted, that they're safe, that they really are going to be acting in the best interest of that person who can no longer make their own decisions. Unfortunately, if a person waits that long, that's very expensive. It's very stressful. It can involve lots of cognitive assessments and court hearings. So, and it depends on the state, but it in general, a guardianship is going to be a stressful and expensive process. And
so the bottom line and the takeaway message is, let's try to avoid guardianship.
Yes.
Let's try to get these very important legal decisions made early. And it is stressful. I totally understand that. Even my situation, I procrastinated. I had one set of papers. I did not like the attorney. This is something else, a takeaway for you. If you do not like the attorney that you worked with and it was not a satisfactory process, or the communication was not there, do not be intimidated. Ask for your paperwork. Ask for what has been done and change. Go to somebody else. You are not trapped in or married to an elder law attorney, or any attorney for that matter. At any point during this process, you can gather up your paperwork and take it to somebody else. So don't feel like you are locked in to one person.
yes.
Because I think that's...
Yes, yeah. I think people are intimidated a lot of times by going to see an attorney, and it's this very serious process. But exactly like Sarah said, you should feel that you can communicate with that person. And if they're not really listening to you, then know that you're in the driver's seat. That, even if they've maybe taken some of their fees up front and you feel like, oh, I've given them a lot of money and I have to finish the process, whatever they haven't earned, you have the right to ask for it back. And you should know that you're in the driver's seat. When it comes to the attorney-client relationship, that's one of the biggest things that you're supposed to learn in law school is, the client is the one making the decisions. You're the one walking them through the legal system and the legal process. But just remember that when you're the client, you're in the driver's seat, and don't hesitate to ask for, like Sarah said, your documents. If you're not comfortable, ask for fees to be returned, and know that you have more power maybe than you would think.
Yes, I cannot underscore that enough. So let's go upstream, because I had that unfortunate experience where I was with an attorney that did not meet my needs, which I didn't even know they didn't meet my needs until I met Katie. And there's some other wonderful elder law attorneys in my life that I've gleaned from a lot. So you don't know what you don't know. So I think it's so important to know that you can have a personable relationship with a human, and that human understands the law, and that human is not making your decisions for you. That human is there, like Katie was saying, to walk with you through this journey and to serve your needs. So if someone is not yet caught up with the wrong attorney, hopefully that doesn't happen too much, and they are still looking for an attorney, what would you say, especially if they're not in your service area, what would you say, what's a good way of looking to look for the right fit for you?
Yeah, so I would encourage anyone to look around, whether you look on, Google Maps or something similar. Look at who's available to you, who's in the area that you're willing to go to, or who's in your state, and if you're willing to work remotely. I would say call their office and see if their staff is friendly and helpful. See if they seem to really care about your concerns, or if they're just trying to shuffle you through an anonymous system. And try to trust your instinct. If you feel like there's a good system in place that you can work well with, if you feel like they care, that's probably a good indication.
Yeah, I like what you said. So look at Google reviews online. Is there a like a Florida state approved list that for of estate attorneys, or there's not a list that somebody can go to and really to pull up a list that doesn't really exist?
Not
You have to
necessarily.
you have to just look at your estate planners within your county or city.
Yes.
And I would also say go to their social media profiles, see if they have a website, see if, and also word of mouth. For me, word of mouth is so powerful.
Yes.
Because if you know of someone who's had the same experience as you had, whether that's good or bad, that's a very powerful testament. So, I think sometimes they will do a free consult.
Yes.
Katie, so that's a good thing to look for.
Yes, a lot of attorneys will do a free phone call or a free consult, and that's a good opportunity to see if it feels like a good personality fit, and if they're respectful of all of your input that you have on the situation.
Yeah, that's very good advice, Katie. Thank you so much today to sit here with us and unpack elder law and estate planning. There are so many variables there and things we need to know, and I'm just so grateful that we had the opportunity to share with our audience all this valuable information. You guys can follow us on our website, boatsmemorymethod.com. We have a newsletter that you can sign up, rich with information, monthly released on the 1st. We also have a bouquet marketplace where we list the best dementia products that we can find, so that we take the guessing out of the situation for you. Just visit the bouquet marketplace and you can find any kinds of products and some of our partners. And on our website also, you'll see a list of our trusted partners in the community that will help you feel more confident on your dementia journey. Thank you so much for joining us today. Thank you so much, Katie. Go have a wonderful rest of your birthday.
Thank you, Sarah. It was such a pleasure talking with you today.